Good evening. Hello, everyone. Welcome to this prestigious International Mediation Conference. I am Thiruvengadam BC, Honorary Director of Bangalore International Mediation, Arbitration and Conciliation Center. On this occasion, we are privileged to have with us His Lordship, Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India. Honorable Madam Athita Komindr, Head, UNCITRAL, Regional Center for the Asia Pacific. His Lordship Justice Cyriac Joseph, Aayukta, State of Kerala, and the Chairman of BIMACC. And His Lordship Mr. Justice S.R. Bannurmath, Chairman, Karnataka State Law Commission, and Vice Chairman of BIMACC. I extend a warm welcome to our honorable guests, speakers, the Board of Governors of BIMACC, members of the media, and all the attendees on Zoom and YouTube from Australia to America. The theme of this conference is social justice through mediation. The famous social jurist Roscoe Pound, who had also propounded the concept of structured mediation, has written in his book, Justice According to Law, as follows, I quote, "Experience developed by reason and reason tested by experience have taught us how to go far toward achieving a practical task of enabling people to live together in politically organized communities in civilized society, with the guidance of a working idea, even if that working idea is not metaphysically or logically or ethically convincingly ideal." What the law has been trying to do is to adjust relations and order conduct to give the most effect to the whole scheme of expectations of men in civilized society with a minimum of friction and waste, unquote. Pound also said that law must be stable and not static. The Honorable Supreme Court of India, in the famous Golaknath's case, observed that law must be dynamic. If a society has to exist with minimum friction or conflict, it must have an effective dynamic justice dispensation mechanism. Social justice means fairness and equality before law. Social justice has no room for differentiation or discrimination based on color, gender, religion, or wealth, etc. Not many in India can afford arbitration or even protracted litigation. For workable social justice, the society, which would also include the state, the judiciary, and the lawyers, should provide options to the people to resolve disputes amicably without burdening the courts. It is not merely the ease of doing business that a country should look for, but also the ease of living with peace and harmony. With 4 decades of standing as a litigation lawyer, as an arbitrator, and 2 decades of experience in mediation, I firmly believe mediation is an appropriate social justice tool because it not only resolves disputes, but resolves conflicts. Conflicts manifest into disputes, and thus, mediation is very important to restore relationships too. Thank you very much. I now request His Lordship, Mr. Justice Bannurmath, to kindly speak.
So you're on mute, sir. Kindly unmute. Thank you.
1 minute. Good evening to you all. I'm delighted by the virtual presence of each one of you this moment at this International Mediation Conference of BIMACC, that is Bangalore International Mediation, Arbitration and Conciliation Centers International Conference. It is late Friday night in Australia and Seoul and pre-dawn Friday in the east of America. It is lovely to have you, our guests, esteemed speakers, and attendees from all over the world. We have virtual presence of His Lordship, Honorable Dr. Justice Dhananjay Chandrachud, Judge of the Supreme Court of India. Everyone in this conference is privileged to have you with us, sir, and we are eagerly awaiting to listen to your address. Welcome on my behalf and on behalf of BIMACC. I also welcome Honorable Madam Athita Komindr, Head United Nations Commission on International Trade Law, UNCITRAL, Asia Pacific region. Your participation means a lot for the BIMACC and in the cause of mediation. Even though it is very late evening in Seoul, it is very kind of you to be present at this moment. I welcome our chairman, Honorable Justice Cyriac Joseph, former judge of the Supreme Court and presently the Aayukta of Kerala. I also welcome our co-vice chairman, Mr. Justice Deepak Verma, former judge, Supreme Court of India. I extend warm welcome to the other honorable members of Board of Governors. The response to this program is tremendous, and I heartily welcome all the judges, past and present, of the Honorable Supreme Court, Honorable High Court and subordinate courts, mediators, teachers, and students from various parts of the world witnessing this event. I take this opportunity to briefly introduce to you all to the BIMACC. BIMACC was launched on 23rd September 2013, and it has emerged as the first largest non-profit comprehensive institutional ADR center in India and one of the fastest emerging centers in the world. The objective of BIMACC is to offer affordable alternative dispute resolution options to disputants and open them for medium, small, and micro enterprises and family and community dispute resolutions nationally and internationally. BIMACC provides for dispute resolution options for domestic and international arbitration, mediation, conciliation, neutral evaluation, collaborative settlements, and mentoring. BIMACC is a pioneer in online dispute resolution and is on the verge of launching a completely digital arbitration platform called EAS, Electronic Arbitration System. This platform is unique because it is entirely digital fast-track platform, caters to small disputes as low as rupees 10,000 or $1,000 American dollars, and significant for the disputes also. It will have more than 1,000 arbitrators across the globe on the panel duly trained in electronic arbitration. BIMACC assists enterprises by nominating neutrals in the prevention of sexual harassment committees and trains personnel in conflict management. BIMACC's ADR is extremely popular. Disputants from various countries have successfully availed BIMACC's mediation and arbitration services. It is cost-effective and expeditious. We at BIMACC are committed to social justice. We periodically conduct free mediation clinics for the economically weaker section of the society and have resolved hundreds of disputes. Since 2014, we have handled 73 international arbitrations, 102 domestic arbitrations, 61 international mediations, 1,556 domestic mediations, including free mediation. BIMACC Academy also offers international standard training in ADR. The BIMACC provides three-tier training program in arbitration, level 1 for domestic arbitration, level 2 for international arbitration, and level 3 for domain experts. 50 hours of accredited mediators training program is given. Advanced course in mediation and arbitration is provided. Training in conciliation, neutral evaluation, and collaborative settlement and mentoring. BIMACC ensures pre-screening of trainees before admission to the course. Trainees are certified only after strict evaluation and getting the necessary grades. We support various legal aid and ADR clinics of colleges and universities like National Law School of India University, Jain Deemed University, Presidency University, SDM College of Law, Ramaya Institute, NTTF, etc. We assist not-for-profit organizations in establishing ADR and mediation centers. We have launched the Bangalore Chamber of Industries and Commerce and BIMACC Mediation Center. BIMACC has been conducting several conferences, seminars, webinars, educating people about importance of ADR and resolving conflicts. It has very active research and development wing, Young Arbitrator Forum, Young Mediators Forum, and new forum called as Bar Gaining, BAR, that is Bar of the Advocates, Bar Gaining, a forum for senior advocates. BIMACC has signed a cooperation agreement with leading ADR institutions globally, including the famous Chicago-Kent College of Law, Illinois Institute of Technology, USA. BIMACC is recognized by the Government of India and few high courts too. The arbitration rules are in consonance with UNCITRAL rules. I'm very happy to state that leading global ADR institutions like France, Italy, Belgium, Egypt, and Hong Kong have entered into MOU with BIMACC for training and mediation issues. BIMACC, being a not-for-profit body, is willing to extend its support to the judiciary, be it in training or ADR resolutions. I hope next day, tomorrow's sessions will be helpful to all of you. Once again, I welcome all of you. Good day.
Thank you, my lord. May I request now His Lordship Justice Cyriac Joseph to deliver his speech. My Lord Justice Cyriac Joseph. Kindly unmute, sir. Can you need to unmute your audio, sir. Yes, thank you.
My own. Oh. Can you hear me?
Yeah, we can hear you, sir. Please.
Honorable Mr. Justice Chandrachud, Honorable Justice S.R. Bannurmath, Honorable Justice Deepak Verma, Ms. Athita Komindr, Mr. B.C. Tiruvangada, distinguished participants, ladies and gentlemen. being the chairman of BIMACC, I feel privileged to preside over this international conference on mediation. Justice Bannurmath has already introduced the BIMACC and its activities. I do not wish to repeat them. Just a stray thoughts for this occasion. Can you hear me?
Yes.
Are you hearing me?
Yes, sir, we can hear you. Please continue.
I am sorry, there was some net connection. As we know, the Universal Declaration of Human Rights was adopted and proclaimed by the UN General Assembly on 10th December 1948. The essence of the human rights elaborated in the Universal Declaration of Human Rights was achievement of justice for all peoples and all nations. Hence, justice is a universally recognized fundamental human right. This is the first point I would like to share with you on this occasion. It is a universally recognized social justice is a universally recognized fundamental human right. While adopting the Constitution of India, the Constituent Assembly, on behalf of the people of India, solemnly resolved to secure to all its citizens justice, social, economic, and political. Hence, social justice is a constitutional value in India, and securing it is a constitutional goal. As per Article 51A of the Constitution, it shall be the duty of every citizen to abide by the Constitution and respect its ideals. Therefore, it is a fundamental duty of every citizen to uphold and promote social justice. The main function of the judiciary is to adjudicate and resolve disputes between citizens and citizens, and between citizens and citizens, or citizens and the state, or a state and another state. But while discharging this function, judges have to uphold and protect and promote social justice. Considering the limitations of the courts and the practical difficulties in their functioning for securing speedy justice, the Parliament incorporated Section 89 of the Code of Civil Procedure to provide for settlement of disputes outside the court. Section 89 recognizes different alternative dispute resolution methods. One of such ADR methods is mediation. The first manual for the training of mediators in India was prepared and published by the Bangalore Mediation Center in 2007. Bangalore Mediation Center was the initiative of the Karnataka High Court. Mediation was conceived as an alternative process of dispute resolution in which a mediator helps the parties to negotiate a settlement of their dispute. It is voluntary, as the parties retain the right to decide for themselves whether or not to settle a dispute, as well as the terms of settlement. The final decision to settle or not remains with the parties. Resolution of the dispute through mediation is qualitatively better than resolution through litigation. There are various reasons for that. Dispute resolution through mediation is less expensive. It is more speedy. It protects and preserves relationship between the parties. It may facilitate settlement of connected cases and disputes. It lessens the burden of the judiciary or burden of the courts, because so many cases, disputes are being settled outside. It promotes justice rather than technical interpretation and decision. They can be generous, they can be forgiving, they can be forgetful. They can forget and forgive to arrive at a resolution, and it protects the relationship between the parties. In this context, we should also remember that apart from court-annexed mediation, there are private mediations also. And there are more private mediations possibly now in India. BIMACC is classic example, one classic example. There are other, in Bangalore itself, there are other private mediation centers. And therefore, we should recognize the role of private mediation in the resolution of disputes and the promotion of social justice. Let me be very frank. With my experience as Chief Justice of the Karnataka High Court, when the Bangalore Mediation Center was started, I can tell you that the success of mediation, this method of alternative ADR method of mediation, will depend on the leadership given by the Chief Justice of the High Court. If the Chief Justice is determined to promote mediation and social justice, he will be able to do it. And if he is not interested, nobody else can do it. Same thing about the Supreme Court also. I say this being a judge of the, since I was a judge of the Supreme Court, and since I was instrumental in drafting the manual, mediation manual there, I know it. Therefore, I am saying, if the Supreme Court does not come forward to endorse and help and promote, assist and encourage mediation, including private mediation in this country, the mediation is not going to be a great process in our country. I am happy that Honorable Justice Chandrachud, who is expected to be our Chief Justice soon, is present today and he is hearing what I am saying. Sir, we look forward to you to give your full support to the mediation centers, whether they are court annexed or private mediators, so that we together will be able to ensure that social justice prevails in our society, and we try to achieve it through mediation. With these few words, I conclude my chairman's address. Thank you.
Thank you, my Lord. Now I may request Lord Dr. Justice Chandrachud to deliver his keynote address. We are eagerly awaiting for his talk.
Thank you. Our very distinguished international guest of honor, Ms. Athita Komindr, Justice Cyriac Joseph, Justice Deepak Verma, Justice Bannurmath, and distinguished guests from overseas in India and everyone associated with BIMACC, including Mr. Thiruvengadam. BIMACC has been at the forefront of setting up India's first international mediation center, dealing with commercial, corporate, intellectual property, family, and consumer disputes, to name some. It is truly international because it has impaneled international mediators. The center has framed its own rules of procedure in tandem with international standards. It provides the facility of online mediation, which would be extremely beneficial during the COVID-19 pandemic. Technology has changed the face of courts, the legal profession, and society. But lockdowns have not slowed down the influx of disputes. In fact, they may have aggravated disputes relating to contract default, non-payment of salaries, to employees and layoffs, among other issues. There has been a reported rise in cases involving domestic violence against women. In such a situation, it becomes imperative that our alternative dispute resolution mechanisms, along with the courts, remain functional to redress the grievances of our citizens. Professor Mark Galanter, the very distinguished professor from Wisconsin, commented that it is a myth that the Indian public is excessively litigious. In 2009, Professor Galanter noted that the volume of civil litigation coming before the courts is reducing. In fact, he says there is evidence to suggest that the per capita civil courts use in India is among the lowest in the world. He believes that Indian courts are congested because of an insufficient number of courts and procedural tactics which are used by lawyers and litigants to halt and delay court proceedings for their own benefit. This, he thinks, affects those who require prompt remedies and protections against dominant parties, such as women from husbands, laborers from landowners, and citizens from government. Backlog and delay provide a profound disincentive to settlement. Defendants who have achieved preliminary injunctive relief benefit from the time value of money by refusing to settle, even in cases where they are likely to lose. While it may be an incorrect perception that India is litigious, our courts are indeed burdened. There are close to 1,44,507 pending civil cases in district and taluka courts, and 41,68,786 cases in the high courts, according to the data available with the National Judicial Data Grid. The last week in the Supreme Court, and I speak for myself, my court was assigned close to 175 cases, between 175 and 200 cases. Mediation then becomes a means of resolving disputes, which is not bogged down by outmoded procedures and practices, is inexpensive, swifter, and not formalistic. However, the role of mediation, other alternative dispute resolution mechanisms, is not merely to reduce the backlog of cases or the cases in the court's docket. Since mediation is not adversarial, it presents a possibility of looking at disputes not as zero-sum games. It provides an opportunity to reformulate relationships in the interests of all stakeholders. Mediation, therefore, can perhaps be used to establish long-lasting peace without sacrificing justice, fair play, and equity. Commentators have raised concerns that the flexibility offered by mediation may allow negotiations to be susceptible to emotional intimidation, assertion of financial leverage, and non-legal considerations may intrude into the domain of what should be legal decision-making. The field of social justice especially presents itself as a thorny terrain because there is a lack of equity between the parties who may be resorting to mediation. Thus, it begs the question whether we imagine justice being done without law courts. The underlying assumption in this criticism is that power is balanced in the courtroom. However, people may not be able to deploy rights equally in courts on account of socio-economic constraints such as caste, gender, economic status, sexuality, and disability. Work done in the field of critical legal studies has highlighted that more laws and more rights are not equal to more justice. Law courts have their own limitations, and I can speak about them as a judge, frankly. For instance, in a recent judgment in Patan Jamal Wali versus State of Andhra Pradesh, I noted the limitations of single-axis legislations, which focus on oppression on account of a singular source, be it caste, gender, or disability, noting that they make invisible the experiences of minorities within these broader groups who suffer on account of multiple oppressions. Citing the work of Nitya Nair, I observed that such legislations require oppressed groups to caricaturize themselves so that they fit into laws' prefabricated, rigid categories. It is possible that issues of social justice may be reduced to a quibble between lawyers and judges about the application of legal formulae. The point of the above discussion is not to be dismissive of law courts. Courtrooms remain places which allow marginalized groups to demand accountability from the state and challenge the status quo. I'm merely questioning the assumption that courts may necessarily be the only sites which can resolve complex issues of social justice, while mediation may fail to provide effective solutions to such conflict because of the power imbalance between the concerned parties. As it is important for a judge to be cognizant of the social hierarchies while adjudicating any social justice issue, it is important for a mediator, as a neutral facilitator, must be able to understand the complexities of the conflict, its causes, which often include systemic discrimination, resulting in a denial of economic, social, and cultural rights of identifiable groups. For this, the mediator may rely on domestic or international jurisprudence or norms such as those which are developed by UNCITRAL and in academic literature. Thus, the pursuit of justice does not have to be necessarily sacrificed in the interest of peace, and the mediation process can be imbued with human rights concerns. Mediation may empower the oppressed party to directly participate in decisions about their future and those of their oppressors. It does not require them to relinquish control to a legal counsel and fit their grievances in a language that the law understands. As some commentators have pointed out, an adversarial process often escalates conflict, encourages scapegoating and victim behaviors, and reinforces just those factors that contribute to social abuse. Non-judicial reconciliation techniques have been previously used to redress human rights concerns. In post-apartheid South Africa, the country sought to face its past of racial segregation, discrimination, oppression, and violence by the establishment of a Truth and Reconciliation Commission. The commission in South Africa was given the responsibility of unearthing gross violations of human rights committed on all sides between 1960 and 1994, granting amnesty to perpetrators subject to their admission of abuses and compensating victims for the ultimate purpose of promoting national unity and reconciliation. Though it did not completely resemble a mediation setting, the Truth and Reconciliation Commission held hearings where both victims and perpetrators were heard to arrive at a useful compromise. The Truth Commission was premised on the notion of restorative justice, reminding us that justice does not always have to be punitive. While there has been some criticism of the Truth Commission that it fell short of challenging structural inequalities that led to apartheid, what the Commission did achieve was that it prevented collective amnesia about the racial past of the country, which itself emerged as a constitutional democracy through a negotiated settlement. The recovery of truth about human rights violations was found to be more useful for reconciliation than a denial of such violations, whether or not accompanied by prosecutions. If perpetrators were acquitted due to a failed prosecution process, it would have added to the culture of impunity, eroding faith in the rule of law and generating anger and cynicism in the minds of victims and survivors. However, The success of any reconciliation project aimed at achieving social justice depends upon translating the rhetoric of reconciliation to reality by tackling deep-rooted social imbalances that underlie the culture of violence and oppression in our societies. Closer home, Lok Adalats have been statutorily established to arrive at amicable settlements for disputes. The Civil Procedure Code was amended to allow courts to refer disputes to be settled by alternative dispute resolution mechanisms, including mediation. High courts and private organizations have taken the initiative of establishing their own mediation centers. Matrimonial disputes are often referred to mediation by the judges. I, in fact, referred one to a very distinguished mediator attached to the Bangalore Mediation Center very recently. These typically involve cases under the Dowry Prohibition Act, maintenance under Section 125 of the CRPC, Protection of Women from Domestic Violence Act, Guardian and Wards Act, matters related to divorce, judicial separation, and restitution of conjugal rights. Courts often refer matrimonial disputes involving criminal charges to mediation. However, matrimonial disputes often involve questions of gender justice. The feminist movement, with its popular slogan, "Personal is political," has highlighted that everything that occurs at home, which previously escaped scrutiny under the guise of the private sphere, should be of public concern. The private sphere not only becomes a site of violence against women, but also perpetuates gender hierarchy by burdening women with caretaking and child-rearing responsibilities, which further affects their public participation. This requires that mediation settings are cognizant of the insidious ways in which patriarchy functions and does not let resolution become another way of perpetuating and reinforcing gender hierarchies. While it may be argued that mediation allows perpetrators to escape legal penalties, it allows women to decide what will be the terms of the reparations to them. This may be more useful than penalizing of the perpetrator, which often depends on the success of the investigative and prosecutorial process. Another area of concern of social and economic justice, which may become important, is labor disputes. The Industrial Disputes Act of 1947 empowers the government to refer disputes to conciliation officers to mediate disputes between employers and workers. The dispute may relate to conditions of work, regularization of employment, deprivation of minimum wages, layoffs, and retrenchment. The conciliator cannot coerce management or labor, but guides them towards an amicable settlement. The conciliation process is centered around the notion of collective bargaining, which poses a challenge to the legal entitlements of the employer in the nature of freedom of contract and the right to property. It seeks to establish a face-to-face interaction between employers and employees under conditions of equalized bargaining power, resulting in the pursuit of better wages or working conditions through a procedure and remedy which is not necessarily legalistic. However, it has been observed that employers generally tend to have an upper hand in the conciliation process. They often use delay tactics to tire employees who raise individual disputes, forcing them to either withdraw or settle. They also often see conciliation as a stepping stone to adjudication. Where conciliation is successful, it depends upon the expediency of the employer that is guided by their financial interests. However, conciliation can be a cheap and quick process. It would also reduce the financial implication that may be borne by workers approaching the court. While conciliation is voluntary in nature, conditions should be created in the conciliation process where employers and workers can negotiate with equalized bargaining powers. Further, there should be an added impetus on conciliation officers to take steps to resolve disputes involving employers and employees, instead of merely acting as a post box for referring disputes to adjudication. I would love to end towards the end of my presentation with this famous quote by Mahatma Gandhi when he said that the true function of a lawyer was to unite parties riven asunder. the lesson was so indelibly burned into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. When I try and mediate as a judge in pending cases, I realize that I'm far from losing my soul, and I'm very close to the face-to-face, to be face-to-face with human justice in all its dimensions. Mediation has the potential to be one of the avenues through which social justice can be achieved, provided it resorts to balancing the social power in the mediation setting and does not promote a culture of impunity. Instead of an institutional culture where the voices of judges and lawyers are at the center, mediation can be a bottom-up strategy which passes the mic to the oppressed groups who narrate their lived experiences, unhindered by the formalities and categories of law. They are able to structure the remedies and reparations that they seek. At the same time, it puts the onus on the dominant groups in our society to contribute to the healing of a fractured society by attempting to do better. I would once again like to thank BIMACC for inviting me to speak at this conference on a subject that is indeed close to my heart, that is social justice. I wish the center all the best for the future, and I hope to engage more and more with the expert mediators of BIMACC as we refer cases for mediation to them. Thank you very much.
Thank you very much for your keynote address. It was very, very profound, and we had a perception of your thoughts as well as the common feeling that we all share. We deeply appreciate, and we're also honored that you participated despite all your time constraints. We are humbled, I should say. So thank you very much. And now I request our dignitary from the United Nations, Honorable Ms. Athita Komindr. Very briefly, Madam, let me introduce just a couple of words because many may not know you in India. Ms. Athita is a lawyer from Harvard, and she had rich experience before joining the United Nations in various sectors in Thailand. I don't want to elaborate, all the profiles are available. And she's been doing a marvelous service as the head of the Asia Pacific region of the UNCITRAL. Over to you, Madam. Thank you.
Thank you very much, Director. Could I please ask your colleagues to show my slides?
Sure, Madam.
Thank you very much. I will go ahead and start while we're waiting for the screen to show. Thank you. Thank you very much. Honorable Justices, Honorary Director B.C. Tiruvengadam, BIMACC colleagues and participants from India and beyond, greetings from the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific, or UNCITRAL RCAP, in Incheon Republic of Korea. It is an absolute honor and pleasure to join you today and virtually introduce UNCITRAL's mediation instruments, including the United Nations Convention on International Settlement Agreements resulting from mediation, or the Singapore Convention on Mediation, the accompanying model law, and the latest mediation-related developments from the ongoing 54th session of the Commission in Vienna, Austria. A special thanks to the Bangalore International Mediation, Arbitration, and Conciliation Center for organizing this important conference and for the excellent arrangements. So this conference is poignantly titled, could we go back to the previous slide, please? Thank you. This conference is poignantly titled Social Justice Through Mediation, as we've already been discussing. Now, most fittingly, the United Nations Secretary General, Antonio Guterres, highlighted the Singapore Convention on Mediation in the latest annual report on the work of the organization, noting that the convention is a positive achievement in the area of international justice and law. The Secretary General stressed that the convention implements Goal 16 of the Sustainable Development Goals as it enhances access to justice for all by facilitating the use of mediation, a simpler and more easily accessible method of dispute resolution in many instances than complex litigation and arbitration, to resolve cross-border commercial disputes. Amicable solutions between parties to cross-border commercial disputes resulting from this mutually agreed method in turn contribute to the development of a mature, rule-based global commercial system. Next slide, please. By way of background, UNCITRAL began its work in mediation as early as in the 1980s, with the understanding that there is a need for unification of mediation regulations, and reached several milestones with the substantive contributions of states, international, intergovernmental, and non-governmental organizations. But for a long time, the use of mediation in cross-border commercial disputes was challenged for lack of an efficient and harmonized framework for cross-border enforcement, in contrast to arbitration, which benefits from the auspices of the nearly universal Convention on the Recognition and Enforcement of Foreign Arbitral Awards, or the New York Convention. In response to this need, in 2018, UNCITRAL developed two instruments in parallel in an effort to further promote mediation as an effective dispute resolution method: a convention providing a uniform and efficient framework for the enforcement of international settlement agreements resulting from mediation, and an update to the model law of 2002. Such a multilateral lawmaking process provides states with the flexibility to adopt either the Singapore Convention, the model law as a standalone text, or both the convention and the model law as complementary instruments of a comprehensive legal framework on mediation. Next slide, please. The Singapore Convention on Mediation opened for signing in Singapore on 7 August 2019. As you may know, India is among the 46 original signatories that signed the convention on that historic day, making the convention one of the most successful developed by UNCITRAL thus far in terms of signatures obtained on opening day. By way of comparison, the New York Convention had only 10 signatories initially in June 1958. Could you go back, please? Thanks. Since opening day, more countries have signed on to the Singapore Convention on Mediation, namely Armenia, Chad, Ecuador, Gabon, Guinea-Bissau, Ghana, and Rwanda. The most recent is Brazil, which signed on to the convention this April. The current 54 signatories already represent over half of the global population and include the world's two largest economies, the US and China, and 3 of the 4 largest economies in Asia, namely China, India, and South Korea. Approximately half of the signatories are in our region, the Asia-Pacific region, and the growing number of signatories demonstrates how the Singapore Convention is attractive to states with different legal, social, and economic systems. Next slide, please. On 13 March 2020, the ratification of the Singapore Convention on Mediation by Qatar, which is the 3rd ratifying state as required by the convention, triggered the convention's entry into force on 12 September 2020. The current 6 ratifying states also include Singapore, Fiji, Saudi Arabia, Belarus, and Ecuador. UNCITRAL is very excited for the continuous international support the Singapore Convention has been receiving and looks forward to more countries signing and ratifying the convention, including India, where mediation holds enormous vibrancy and promise, as discussed by today's distinguished speakers. Next slide, please. I now turn to some key provisions of the convention. For the sake of time, I would like to focus on its scope of application, general principles, and grounds for refusing to grant relief. So Article 1, read with the definitions in Article 2 of the convention, sets out its scope of application, namely that it applies to international agreements resulting from mediation, concluded in writing by parties to resolve a commercial dispute. Disputes arising from consumer, personal, family, or household purposes are not included, and neither are settlement agreements which have been approved or concluded by a court and are enforceable as such, nor settlement agreements recorded and enforceable as an arbitral award. Article 3 sets out the general principles of the convention and provides that each state party shall enforce a settlement agreement in accordance with its rules of procedure and under the conditions stipulated in the convention. Article 5 sets out the limited grounds for a competent authority of a party to the convention to refuse to grant relief, such as that a party to the settlement was under some form of incapacity, if granting the relief would be contrary to the public policy of the enforcing state, which is party to the convention, or if there has been a serious breach of mediator standards. Like the New York Convention, the Singapore Convention on Mediation strengthens respect for binding commitments, inspires confidence in the rule of law, and ensures fair treatment in the resolution of disputes arising over contractual rights and obligations. And like the New York Convention, benefits of the Singapore Convention will only be amplified as a number of state parties increases. Next slide, please. I would now like to briefly mention the 2018 UNCITRAL Model Law on International Commercial Mediation and International Settlement Agreements resulting from mediation. Passed by the Commission in 2018, this legislative text is available for states to adopt through domestication and amends the UNCITRAL Model Law 2002. The Model Law of 2018 is designed to assist states in reforming and modernizing their laws on mediation procedure and provides uniform rules in respect of the mediation process and aims at encouraging the use of mediation and ensuring greater predictability and certainty in its use. The 2018 Model Law also includes a section on international settlement agreements, incorporating the key provisions of the Singapore Convention on Mediation, and can thus be used as a basis for enactment of legislation on mediation, as well as the Singapore Convention. Next slide, please. In addition, although the Singapore Convention, along with the 2018 Model Law, constitute significant milestones, there is still work to be done. Currently, UNCITRAL is in the process, right now, this week, of adopting a guide to enactment and use of the UNCITRAL Model Law, updated mediation rules to reflect current practice and ensure consistency with the Convention and Model Law, and notes on mediation, which would provide the users with some guidance on the mediation procedure. As noted by delegates, these tools would further facilitate the effective usage of mediation and complement the Singapore Convention and Model Law. All materials are available on the UNCITRAL website, including the sample procedural flow chart from the notes on mediation shown here, and the links are there on your screen. Next slide, please. Before I end my remarks, allow me to briefly introduce the Regional Center. To promote the use and adoption of UNCITRAL texts, in addition to national legislation reviews, the Secretariat undertakes two other main activities: the provision of technical assistance, along with the collection and dissemination of information on developments in the field of international trade and commercial law. The core of the work undertaken by my office, UNCITRAL RCAP, lies here, focusing on jurisdictions and stakeholders in the Asia Pacific. The UNCITRAL Regional Center for Asia and the Pacific is UNCITRAL's only regional center, opening our doors since 2012 with the support of the South Korean government and also Hong Kong SAR China. Next slide, please. For participants interested in learning more about UNCITRAL, I invite you to join the Regional Center's upcoming virtual events throughout the region, particularly our flagship events currently shown on your screen. Next slide, please. Last but not least, for our academic colleagues in the audience, the Regional Center invites you to co-host an event under the UNCITRAL Asia Pacific Day flagship series. This is an annual series of academic activities that RCAP co-hosts with institutions of higher learning on a wide range of UNCITRAL thematic issues. In so doing, we aim to raise awareness of the international commercial legal landscape and the role of UNCITRAL to law students and other stakeholders. In 2020, UNCITRAL RCAP co-organized a total of 19 UNCITRAL AP Day events with 35 institutions in 10 jurisdictions, including India, which hosted two of our biggest events. For more details on the AP Day series, we invite you to visit its dedicated webpage, and the link is shown there. Last slide, please. UNCITRAL RCAP invites you to peruse our webpage and subscribe to our mailing list via the QR code shown there. Thank you again for honoring UNCITRAL with today's invitation. And thanks again to BIMACC, and congratulations on this successful conference.
Thank you very much, Madam Komindr, for highlighting the key features of the Singapore Convention, the need for it. And of course, India is a signatory to it, and I had the privilege of participating in this signing ceremonies too. We are honored by your presence, and we hope and certainly hope that UNCITRAL will give the support to BIMACC and all such not-for-profit institutions around the world for the cause of mediation. Thank you very much. With this short inaugural ceremony, which is very, very memorable in the history of mediation, would come to an end. And before that, I'll be failing in my duty if I do not thank His Lordship Justice Chandrachud for sparing his valuable time, the two after a busy day in the courts. And he's also heading the E-Committee of the Supreme Court, and is bringing a revolution throughout. And India is one of the countries which is, I should say, as a litigator, we have been seen impossible thing happening. We are having virtual hearing, and which is so beneficial to many. Okay, so thank you very much, my lord, for the year, and Madam Komindr for your presence again, and to my chairman, His Lordship Justice Cyriac Joseph, and His Lordship Justice Bannurmath for their participation in this short function. And to all the attendees who are present here, please do not, thank you very much. And please do not forget to log in and participate in the technical sessions. There are several major mediators and experts from all over the world. Please don't miss it. It'll be certainly useful. Thank you. Kindly remain safe.